I am the chair of the Ninth Circuit Historical Society, and on behalf of the Society and the Federal Bar of the Western District of Washington, I'd like to welcome you here today to the first session of our Courts During COVID program. We have an amazing program tonight, and it is only one of the many programs the Society puts on in keeping with our mission to preserve the legal history of the West and more generally to educate about the importance of an independent judiciary. I encourage all of you to become members or at least get on our mailing list. You can use the link in the chat box to find out more, and we will also email it to you after the program. Before we begin, I have a few housekeeping items. First of all, for all of those who are seeking CLE credit for today's program, you will need to pay attention to the chat box on your screen. A numeric verification code will appear in the chat box about midway through the program. For those of you on the phone, don't worry. Judge Phillips will read the verification code aloud also about halfway through the program. Now, you must record that code in order to receive CLE credit for today's program. After the program is over, you'll need to visit the njchs.org website to complete the CLE verification form on that page. That's where you will enter the code. Once you've submitted that form, the NJCHS will process it and send you your certificate of attendance. The chat box is also the place for you to submit any questions that you have today for our panel. Robin Lipsky, who's the Executive Director of the Ninth Circuit Historical Society, will be monitoring the chat box throughout the program. Okay, finally, although each of our speakers has a much lengthier description of their accomplishments, in the interest of maximizing their time, your time with them, I'm going to give them a very brief introduction. Their full bios have been made available to you as part of the CLE packet of materials on the Society's webpage, and I encourage you to refer to them. We're pleased tonight to have really an all-star panel of judges, lawyers, and court personnel from around the Ninth Circuit tonight. Judge Phyllis Hamilton has been a district judge for the Northern District of California since 2000 and served as chief judge of the district from 2014 until just recently on February 1st, 2021. Prior to becoming a district judge, she also served as a magistrate judge in the Northern District of California. Judge Stacie Beckerman has served as a U.S. magistrate judge for the District of Oregon for 6 years and currently serves as chair of the Ninth Circuit's Magistrate Judge Executive Board and chair of the Ninth Circuit's Pro Se Litigation Committee. You'll note some of Judge Beckerman's excellent articles about holding court during a pandemic have appeared in the Oregon District Court Historical Society's publication Benchmarks, and those are included in the CLE materials, and I really urge you to read those. It makes me think that Judge Beckerman must have been a journalist or a writer in a previous life. They're very well done. Idaho's very own Candy Dale. I say that because I'm from Idaho. I'm very proud of Judge Dale, who serves as a U.S. Magistrate Judge for the District of Idaho since 2008 and is the first and so far only woman to have served on the federal bench in Idaho. Among her other duties, Judge Dale is chair of the Local Civil Rules Advisory Committee and serves on the planning committee for the district's annual Teachers Institute. Susan Gilmes is the Chief Deputy Clerk for Operations at the Ninth Circuit. She has been with the court for over 30 years, previously serving as supervisor of the motions and pro se units in the staff attorney's office and as director of the circuit's pro bono program for 22 years. Kiry Gray was appointed clerk of the court for the District Court of the Central District of California on September 24, 2015. Ms. Gray has a long history of service to the court spanning 30 years. She's the first African-American woman to be appointed as clerk in the Central District of California. Mo Hamoudi began his legal career as a solo practitioner in San Francisco in 2010. In California, he served on the Board of Governors of the California Attorneys for Criminal Justice. In 2014, he was hired as Assistant Federal Defender in Seattle, where he has worked on trials and appellate cases, including capital and non-capital habeas matters. Alex Samuels is an Assistant United States Attorney in the District of Arizona, where he has been an AUSA in the Criminal Division since 2014. Alex serves as one of the U.S. Attorney's Office's tribal liaisons in 2018 and 2019 and was section chief of the Violent Crimes section from 2019 to 2020, and currently is section chief of the Indian Country Crimes section. And finally, our moderator for today's program is Judge Virginia Phillips, District Judge for the Central District of California since 1999, and Chief Judge of the Central District from 2016 to 2020. Prior to serving as District Judge, Judge Phillips served as a Magistrate Judge in the Central District from 1995 until 1999. As I said, an all-star panel. Now, without further ado, I'd like to turn it over to Judge Phillips and our very distinguished panel. Thank you.
Thank you, Deb, for those great quick introductions. And let me thank Robin Lipsky and her staff at the Ninth Judicial Circuit Historical Society for all the work they've done to bring this program to you. I'd like to get started by talking about what happened back 10 months ago in March or so, when pretty quickly we had to pivot to do things very differently. I remember when I left my chambers on March 18th in the afternoon, I thought, well, you know, I'll be back in 2 weeks. I'll be back by June. I'll be back in, well, anyway, here we are. We're, for the most part, not back doing things in person. So I'm going to ask Judge Beckerman up in Oregon to tell us what are some of the things that you observed in all of the different things that the magistrate judges do in your district to ramp up and deal with this change.
Sure. Thank you, Judge Phillips. I was the lucky magistrate judge on criminal duty for the month of March 2020. And I recall early in the morning of March 4th, so it was early in the month, I received an email at about 6 a.m. It was literally a wake-up call from a magistrate judge in Seattle named Brian Suchita. And he had sent an email to all the magistrate judges on the Magistrate Judge Executive Board. There's one from each district serving on the circuit board. And as you know, Seattle was hit first, largely. And he was dealing with a scenario where the Federal Detention Center at SeaTac had issued a 48-hour lockdown for a suspected case. And this was one of the first times this had happened. So he reached out to all of us and said, how should I conduct the magistrate mag court or the criminal calendar? We can't get people here. There's a lockdown. And we thought about doing it by video, but the AV equipment at the jail happens to be separate from the housing unit, and they won't walk people down to the AV equipment past other people who may be ill. Does anybody have any input? And I responded, but more importantly, what I did was the light went off, and it was March 4th. It's when it first hit me that we need to get ahead of this right away. So I sent the email to my chief judge, Marco Hernandez, who of course was already on top of it. But we assembled an all hands on deck meeting that Friday. So March 6th of U.S. Attorney's Office, FPD, the Marshal, what are we gonna do and how quickly can we move? And a week later, we were up and running on video. We had converted all of our criminal calendar proceedings to video. You know, we tested out platforms. We wanted to make sure that it was user-friendly, not just for court personnel, but more importantly for the lawyers, so that this could be accessible to everybody. But
so
it was—
excuse me, were you doing arraignments, detention hearings, all of that by video within a couple of weeks then?
We were within a couple of weeks. And my takeaway from that is, you know, as you pointed out, we all became tech savvy very quickly because we had to. But, you know, from a historical perspective, looking back, what was sort of amazing about that time was the collaboration of, you know, all the magistrate judges in the Ninth Circuit. And then, you know, we were exchanging ideas almost daily. How are you guys doing it in Seattle? What's happening in LA? And it was really sort of a magical time because that doesn't, you know, judges aren't forced to collaborate all that often. I was reaching out to judges across the country, you know, how are they doing in Colorado? How are they doing in Virginia? And, you know, it was a time of sharing ideas so that we could move quickly. We didn't have the luxury of waiting for national guidance back in March. We just had to go and, you know, try to keep everybody separate in the most efficient way possible. So it was a quick ramp up, but we got it done fairly quickly here in Portland.
Thank you. Ms. Gray, tell me what the ramp up was like in the tiny little district called the Central District of California. 7 counties, 19 million people, 4 courthouses.
Yes. Well, you know,
Go.
yeah, it was really an incredible journey. What I can say was a few years ago, we had started converting all those that were on standalone PCs to laptops and Surface Pros. We're talking 800 people that we had to make sure that they knew how to use their PCs from working remotely. So we relied heavily upon our IT department. I know they were stressed, but I was just so delighted that, like the judge previously said, all hands on deck. We knew we didn't have a choice but to go remotely. And the IT staff got in there, our chair of the IT committee. We had numerous meetings and how we were going to make this happen. And we had just recently consolidated, you know, with pretrial and probation. So like I said, you know, they're there, the end users were 800. And we knew we had no choice but to work collaboratively to keep the court up and running.
Judge Hamilton, can you tell us about the ramp up in the Northern District?
Yeah, thinking back, it all happened so quickly. If you remember Wednesday of, well, I forget the date, but mid-March, the World Health Organization declares a global pandemic. I think it was the next day that the NBA canceled the season. And the following Monday, the Bay Area health authorities and the mayor of San Francisco all declared a shelter in place. We had to close down in a day, essentially. Now, for us, I think I would divide it into our outward face and our inward face, my responses. And with regard to our inward face, we had to think about staff. After all, the goal of all of us was to minimize the number of people in the courthouse in order to mitigate the risk of the spread of the virus. So we had to start first internally. We were not a district in which teleworking was done that with any degree of frequency. And so how do you go from 0 people, how do you go to 0 with 100% of your staff, for the most part, working in the courthouse? That was one of the very biggest challenges. And we ultimately got down to about 92% of our staff working from home, and that still persists today. So it's pretty remarkable, I think, for courts all over the country. We're still up and running and operational, but most of our staffs are working at home. The challenge for that was, as some of the other panelists have mentioned, it was an IT challenge for us because we weren't accustomed to it. And the IT can be divided into in 2 categories, support and equipment. We, luckily had enough support, didn't necessarily have all the equipment. We've invested in more equipment as the pandemic has continued over all these months. But getting our staff up and running, it actually happened pretty quickly. And then looking at our outward face, that was much more of a challenge. Civil cases were a little easier to adapt because we were accustomed to holding telephonic hearings and telephonic case management conferences. And within a few weeks, we were able to transition to video conferencing to add that to the telephone conference lines that we had. We got our Zoom licenses, I believe, towards the end of March. So that transition was fairly easy in comparison. The criminal cases, though, were a problem and are still provide extraordinary challenges for us. Not the least of which is, while trying to eliminate the number of, or minimize the number of people in the courthouse, we are still trying to render justice on individual cases. The CARES Act passed March 27th did provide a great deal of assistance in giving us the permission to do so many things that we had never dreamed of doing remotely. And we were able to do that. But I think one of the best things that I did was to establish a task force. We call it the Santa Rita Jail Task Force because that's the facility in which almost all of our incarcerated defendants are housed. And the task force, which just did wonders, a group of judges, defenders, U.S. attorneys, marshals, probation, pretrial, all the stakeholders on our criminal calendars participate. And for a while they were meeting every day. I think now they meet several times a week even to solve all of the problems. And we were very fortunate to be able to establish a video conferencing capability at our jail. So we were able to do video conference and telephonic appearances. So the challenges were tremendous, both inward and outward, but I definitely think the biggest challenge was the uncertainty, and we still live with that. But like you said, Judge Phillips, you thought when you left that you'd be back in a couple of weeks. Well, I established a set of task forces, and one of the task forces was named the Beyond May 1st Task Force because, oh yeah, by May 1st we'll be back and we'll need to reopen. So I'd say that the one of the biggest challenges that has remained throughout the pandemic is just the uncertainty and not knowing how long we can sustain what we're doing. And one last thing I'd say is back in March, when I thought figuring out how to close the doors to the courthouse while keeping the doors to justice open, I thought that was the hardest thing that we'd ever have to do. Well, come May, I realized that reopening the court and resuming any kind of proceedings is way harder in a pandemic than closing down the court. And we're still struggling and being challenged by how to do that safely.
Thank you. Ms. Gilmes, can you tell us about the different but equally difficult challenges and operations that you faced at the Court of Appeal beginning in March?
Yes, similarly to what Judge Hamilton was describing, I mean, things happened very quickly when they first started happening. And so we were trying all at the same time to deal with, we had calendars going that week, but the following week after the shelter in place, we had a special sitting planned in Las Vegas that was supposed to be at the courthouse there. And there was a big high profile case there and a law school day. And we very quickly went from, well, let's let people not travel if they don't feel comfortable traveling, whether that be court staff or judges or lawyers. Within a couple of days, it was very clear that we were just shutting it down. We were going to do it all remotely, and that was for the next week. Luckily for us as a Court of Appeals, we don't have to deal with things like witnesses, juries, defendants, parties. The only sort of interactive part of the actual court operations are the oral arguments. And because we were already live streaming our hearings for many years and posting them on our website and making them available afterwards, and we had the technology to bring in people by video, that part was not that hard. I mean, ramping it up to include every judge and every lawyer for every sitting beginning immediately was a bit of a challenge. But once we got something in place and we kind of developed a system of when our deputies would reach out to the lawyers and what information we would get from them and how we would set up our Zoom and testing and all of that. Once we got that in place, that part's been easy. We don't, the public still has access to our hearings and everybody who needs to be there can be there virtually and it's not a problem. Ramping up on the staff side, was also a big challenge for us. we did have a fair number of staff in some departments who were all set up to work remotely and who worked remotely from time to time. Our staff attorney's office, certainly, our IT department, some of the others. But the clerk's office had a few people who worked at home once in a while and a lot of people who had never done it. Some of them not only didn't have a computer or a laptop at home, but they didn't even have internet. And again, there was this sort of daily evolution starting from, well, people who are set up can go work at home, let's send them home. But if they don't have internet or they don't have a computer, we're not set up to provide that for everybody. That changed pretty quickly from that approach to, okay, we're giving everybody a laptop and we're forcing you to leave and we'll help you get internet, but you got to get out of here. And since, we basically got it to a place where we created an email address for people to ask questions rather than calling the court so we could respond to those remotely. We created an email address for pro se litigants who are not registered for electronic filing and who have access to email to send us pleadings that way, because we closed the courthouse and have just a little sort of bucket outside, but we still get a lot of mail and paper pleadings. We have, 45% of our filings are pro se, so we get a lot of paper, and our judges still need paper for certain purposes. So I do have a skeleton crew that rotates through the courthouse every day to keep it as small as possible. They all drive. We provide them with parking. We've made it clear we really don't want people taking public transportation. That's still true. It's worked out over time, but that initial scramble was very challenging. And by a few months into it, when we had new law clerks coming on board, some of whom were going to need laptops, we were putting in orders for laptops, and there was a huge backlog because everybody needed them. So we did, even for a while into it, we had some challenges with getting enough computers for everybody. And for our chambers, it was a huge challenge, of course, because they were all used to working very closely together in chambers, and almost all of them, if not all of them, were remote for at least some period of time. Some of our judges are back in chambers, and because there's really nobody else in the courthouse, that's up to each judge in each courthouse. But it was definitely a challenge.
Thank you. And by the way, speaking of questions, I noticed questions are popping up on the screen. We're going to wait till the end of the program, and we'll address as many questions as we have time for then. But several of the speakers already have noted that the greatest challenges were faced in the criminal cases. So I now want to turn to our two criminal law practitioners. And I'll start with you, Mr. Hamoudi. You're a public defender in Seattle.
Seattle, yes,
I
yes.
say Arizona, but that's your opposite number. So can you tell us a little bit about the challenges that you found needed to be addressed by the lawyers in your office at the outset?
Thank you, Judge Phillips. And we were in Seattle. We were one of the first cities that was hit by the pandemic, and our district, led by Chief Judge Martinez, immediately, collectively, and collaboratively with other stakeholders, took on the pandemic and its challenges head on, and did not treat the pandemic lightly. And they collectively listened to the science and responded accordingly. It was clear that protecting jurors, staff, everyone was priority number one. And I'm really proud of the district for doing that. As for a lawyer, a criminal defense lawyer, the work is and was difficult prior to the pandemic. It is even more difficult now. Public defenders, private counsel, and CJA counsel are bound by the Sixth Amendment. Everybody knows that, and that amendment requires us to be effective in how we represent our clients. And this pandemic has confronted our ability to work quite directly. one of the main issues is the lack of access to clients. It is critical to meet clients face to face, not just virtually or on the telephone, to deliver difficult news and advise them so that they can make informed choices about difficult matters. On appointed cases, especially working with indigent persons, building rapport with the client is critical, and that has become quite difficult to accomplish. Investigations, we cannot effectively send investigators to do field investigations in the communities where the virus is rampant. They cannot go knocking on doors. There's a lot of case tasks that have been piling up. And
could I interrupt to ask a specific question? I know that one of the difficulties that criminal defense lawyers have faced in our district is we have worked, I think, very effectively with the BOP and the other jails where our defendants are incarcerated before trial to get their capacity for attending hearings via teleconference. But what happens is that since there's a limited bandwidth for that the lawyers are telling me that often they've scheduled a remote visit with their clients, and then they get bumped because there's a hearing that has to get scheduled. Have you experienced that too?
yes, we've experienced not only that, but periods of time where we've had no contact with the clients. Our facility
conditions in the facilities.
Yes, Your Honor. And the facility, the Federal Detention Center, just recently experienced a significant outbreak. And before that, and there are periods of time where the facility goes on modified to full lockdown. The pretrial detainees are maintained in their cells up to 20 hours a day sometimes. They're only allowed out periodically for showers, limited access to telephone, commissary. They can't see their families face to face, which is really an important aspect in managing expectations and managing the client, because they need to feel that support from the outside, not just from the lawyer. So everybody knows this. It's no new news that long periods of confinement start to have a impact on one's mental health, and that impact specifically starts to bear down on the attorney-client relationship, because when someone is confined, then and I'll give you a good positive example of this. What a positive outcome for individuals who are incarcerated. There's either a trial or there's not a trial. There's a plea agreement. One of two things must happen. Those that are pretrial confined. So settling the case and bringing the case to a closure and coming to sentencing is an important aspect of the process. And when that slows down, it puts a lot of pressure on the individuals. Judge Martinez did something great. Last year, when there was a lot of cases piling up, he took over the master calendar, the master criminal calendar, and essentially put the parties in a situation where they had to confront the case, settle it, or set it for trial, and find out which cases were ready for trial and which cases weren't. That caused a lot of the cases to settle. And it required Chief Judge Martinez to take over the calendars of district judges, which is, district judges like to maintain their own calendars, obviously, but that helped some. But it's now piling up again because the cases are still coming in.
Thank you. Now I want to ask your counterpart, who is in Arizona, Mr. Samuels, to talk about the transition to all of this, the remote proceedings and so forth in your district.
Certainly. Thank you, Judge. I think as Judge Hamilton noted, the challenges in criminal cases across the board, I think, have been especially difficult. We've certainly experienced that In Arizona, I think at the court in general, I think throughout the Department of Justice have experienced that, and certainly at the U.S. Attorney's Office in Arizona have experienced that. Mentioning the Department of Justice reminds me that one of the quirky things about working for DOJ is I have to give a disclaimer at the beginning of a presentation like this, that what you're about to hear is my views and not the views of the Department of Justice. But much like that disclaimer, I think our rollout, at least in Arizona, was a little bit clunky, and sort of was similar to what Susan has described at the Ninth Circuit, where Tuesday we knew we were doing one thing, and Thursday we were definitely doing a little bit more than that. By Friday we were doing something totally different, and there was definitely I would say a 2 or 3 week period where it just seemed to be changing on a daily basis, partially because of, I think, changing attitudes towards the realities of the pandemic, but also partially just because the limited resources we had available. So one of the largest challenges that we faced was in the very early stages, our office decided we were going to transition to full telework as quickly as possible, just for public safety, the obvious reasons. But we did not have the equipment to do that at all. Attorneys were given laptops long ago, and thus even those that were a little technically challenged could figure out how to telework. They were told that they needed to do so. Most of our support staff didn't have laptops, and we didn't have extra ones around to give them. They also didn't have tokens, which we can use to connect remotely. So they had literally no way to connect remotely, at least in the initial weeks. So we were doing all sorts of creative things to try to figure out how to protect our support staff by figuring out how could we give them work tasks that they can do at home. Some of them didn't even have home computers. And we can't have them take home certain things from the office for security reasons. So it was really a challenge to figure out how to protect them and make sure that the work was done. And on the subject of the work getting done, the reality is criminal cases couldn't just stop. They had to continue. And in Arizona, we have a very large criminal docket, both because we're on the international border and because we have such a large Indian country caseload, among other reasons. So we have a lot of hearings here. A lot of them needed to be covered, and we did not transition to video immediately. So another large challenge that we faced in the early days in terms of figuring out how to protect people was, on an ordinary day, we might have a couple dozen attorneys going over to the courthouse to cover one hearing or 2 hearings or maybe a few. We transitioned to court coverage systems where we could have one attorney essentially just stationed in a particular courtroom to try to cover all the hearings that day, so that we had less people going into the office and less people going in and out of the courthouse. None of that happened easily, but we were able to do that. And eventually we did transition to appearing by video. But to your question for Mo about video capabilities and some of the struggles that our court has had in that regard, there was a time period in the spring where attorneys were able to appear by video, and eventually they transitioned to a system where they were able to get defendants on video from jail much more frequently. But in order to do that, it was using so much of the video bandwidth that they no longer had the capability to allow attorneys to appear by video. We've actually been back to in-person, or in some cases telephonic appearances for many, many months now. I've also heard from defense counsel in our district that they've had similar problems to what Mo is describing, even just as it relates to video capacity, where they have a very hard time, if not an impossible time, getting a video appointment with their clients. Even getting telephone appointments, while doable, they have to do it at off hours. The struggles the facility is going through, and it's not always reliable because, you know, their client's pod might get quarantined that afternoon, and then all of a sudden everything has changed and I have to reschedule for another time. And it's definitely, I think, led to a lot of headaches on that end. I think just generally speaking has led, at least in Arizona, to a slowdown in a lot of aspects of how criminal cases are through the system. I certainly think by now we've largely worked out a lot of those issues, and things don't feel normal at all, but feel a lot more normal than they might have in April or May. But I do think even now there have been significant slowdowns in the criminal case system. We don't currently have a grand jury in Arizona. have not had one in November. We also didn't have one from March till September. So we had about a 2-month window with grand jury out of the last 11 months. And jury trials have been permitted during certain times, but have not been permitted for the large portion of that time as well, including right now for the end of February. So it's just been hard to move cases through, and that's been challenging for everyone involved, for defense counsel, for prosecutors, for the court, for our victims and witnesses who are, you know, have a subpoena in hand and keep getting an email once a month or every couple months that the trial's getting kicked down the road. So I think those are just a handful of things that we've did.
Thank you. Let's move forward. I want to ask Judge Dale, who sits in Idaho, to talk about a little bit maybe about your transition, but where do things stand now in Idaho in terms of the kinds of proceedings you're doing, either in the courthouse or remotely, and again, both the initial criminal proceedings, settlement conferences, all the work that the magistrate judges do?
Okay. Well, we've gone through different periods of time. Like the rest of you, in the middle of March, we were all sent home and all of our staff. And so we worked through the remote teleworking issues. I want to kind of make a mention to the role that the U.S. Marshal's Office has made here in Idaho, because as you all can imagine, in Idaho, we have a lot of rural areas, and a lot of our defendants pre-trial are detained in the county jails because we don't have a federal detention center. And so the U.S. Marshals became partners with the court and with the defense attorneys and the AUSAs, and helping us facilitate some of those things that Mo and Alexander have been discussing. But beginning and then in March, we were, as I said, all sent home. And one thing from a historical perspective that was unique to our state is we had an earthquake, a 6.5 earthquake on March 31st of 2020. And I know you're all thinking, well, that's only happens in California, but it happened in Idaho, and we were home, and my husband and I looked at each other and were in a bit of shock as to what was going on. But we all survived, and none of our courthouses were harmed. But so we were shut down. We were doing all of our proceedings remotely for the magistrate judges and the district judges. And then we opened up in June through November, and we had a total of 7 jury trials during that period of time. 5 of them were criminal cases, 2 were civil cases. I had a 2-week jury trial in Coeur d'Alene, which required travel to Coeur d'Alene, which was just a short flight from Boise to Spokane. So I was feeling okay about being on the flight, but then I stayed over the weekend in Coeur d'Alene and kind of sheltered in place when I wasn't at the courthouse. Flying home in late October, I got on the plane and ended up on the plane for 5 hours because of de-icing. So again, just kind of bringing out kind of the unique things about Idaho's geography and how that also impacted us in the middle of the pandemic. But we had, as I mentioned, 7 jury trials in all, at least 1 in each of our 3 courthouses. We have courthouses in Pocatello, here in Boise, and in Coeur d'Alene. And as I mentioned, 5 criminal trials. Fortunately, no one got ill during the course of the trial. We had, we required everyone to wear their masks unless the attorneys could remove their mask when they were behind the lectern, because we had plexiglass in front of the lectern. And we also allowed the witnesses to remove their masks when they were behind the plexiglass at the witness stand. But all other participants during trial, including the judge, we wore masks, and the jury was broken out into 2 or more jury rooms during recess. Depending upon the size of the trial, we had jurors spread out in 1 or more courtrooms for the jury selection itself. And then of course they were distanced while in the courthouse. We tried to utilize Zoom technology for the the civil cases to the extent we could, and having expert witnesses appear by Zoom or otherwise. And we also implemented what we called partial sequestration orders, so that we were able to keep the jurors at the courthouse during the day and provide meals for them. They had to be self-contained meals, but they were we were allowed to use appropriated funds for the meals because of the partial sequestration order. And we did that so that the jurors weren't going out to restaurants that were open in the immediate area. So one of the things that I found, that never expected would be part of the judge's role or litany while on the bench was, after a witness would testify and was being excused, I'd ask the witness to take a Clorox wipe and wipe down the witness stand and the microphone before he or she stepped down. But we were able to have the jury trials. We also impaneled a grand jury in September, a new grand jury, and they were in session. And so we had jury trials through November and grand jury through November. We only have one grand jury though in the Southern Division, and they hear cases from the Northern Division and the Eastern Division. But then we suspended, like the rest of you, I think, suspended any jury trials and grand jury in December. And we are resuming with trials in March. And we have a grand jury here this week for 3 days for the criminal cases. So that's what's been going on the criminal front, on the civil front, but most of our settlement conferences, as Judge Beckerman knows and is doing, we're doing those by Zoom, largely by Zoom, and I'm having pretty much the same level of success with settlement conferences by Zoom, but it's definitely a challenge. And I think one of the biggest challenges is not getting any exercise, because you're just looking at the screen the entire day and you're going in and out of rooms, but without physically doing that. So
Could I ask you, on the cases that you've had that went to trial during this time, and with the grand jurors, what sort of contact tracing are you doing after a trial? Are witnesses and participants in the trial and the jurors, if someone finds out a day or two after they've been dismissed, the case is over, are they contacting the court?
yes, we asked them to do that, and we had that occur in after one of the jury trials, and then all of the other jurors were contacted and informed that that they should take care of themselves and self-isolate. We also unfortunately had a grand juror who was exposed through his wife, and he passed away. He got very sick, and so actually today they were having a little celebration of his life here, but that didn't involve, and so all the grand jurors that were serving at the time were informed, but none of them were exposed at the same time as he was exposed because of when they were meeting. So again, fortunately, but we are trying to do our best with the contact tracing.
Thank you. Judge Hamilton, can you talk about what the Northern District has done in terms of any trials taking place since last March?
Yes, we've had 4 trials. We actually one of our judges was mid-trial when the pandemic hit. And after a number of continuances, he was able to resume and conclude the trial in July. And that was fine. And then, of course, there was additional widespread risk in our community, and we didn't do a lot over the course of the late summer. And then we resumed jury trials in the fall. And in October, we were fortunate. We got 3 or 4 trials, and mostly criminal. Keep in mind, it's our criminal in custody cases that get all the priority that we have. our district has done something that I think has served us very well. In addition to having infectious disease experts give us advice on how to outfit our courts, we have indeed taken the steps to minimize the exposure for everyone by we have 3 courts in our Bay Area district, and each of those courthouses has 1 courtroom designated for trials and 1 courtroom designated for in custody, well, for criminal matters where an in-person appearance is necessary. We call that a hybrid court because half of the participants appear in person, and the other half, such as interpreters, probation officers, appear over Zoom. So in every one of those courtrooms, each station is outfitted with a computer, and the participants are expected to, we talk with the people who are on the computer as well as the people who are in the courtroom. For the most part, we're doing for the guilty pleas and sentencings in the hybrid courtroom. For those defendants who don't care to do it over Zoom or over teleconference. And we have, in addition to the 1 hybrid court in each division, we have 1 jury courtroom in each division, also outfitted with plexiglass and space markers and all of the PPE that is recommended. And we have had our jury trials in each of our 3 divisions. Each of our divisions has had 1 in October. 3 criminal, 1 civil trial actually went. The civil trials don't have the same priority, obviously, as any in custody criminal case, but we're hoping to be able to get to our civil trials at some point, particularly if we're in one of the divisions where there aren't an overabundance of criminal trials. So we're hoping, you know, we look at it on a kind of a bi-weekly basis. We're going to reopen our hybrid courtroom February 16th, and we will be discussing that same day when we can resume jury trials. But given that all of the Bay Area counties are in the purple tier in the California state system, that the metric that the governor has promulgated in August to determine the nature of the risk. As long as the risk is widespread, I'm not sure what we're going to do, but we as a court are acting together, and it's been a pretty remarkable process to for all of us, you know, to arrive at a consensus, to fully discuss all of the issues and arrive at a consensus as to what is safe. We are mindful of our obligation to all of the people who are before the court, who, whether it be criminal or civil, who are entitled to a trial. And we're trying to do our best with regard to in-person trials. Now, one of the questions I saw scroll by the screen was about when are civil trials going to start, and are we interested in Zoom trials? Well, we'd like to start civil trials as soon as we can. I have no idea when that will be. And yes, I think some of the judges on my court are very much interested in doing bench trials and potentially jury trials over the Zoom platform. We would not do criminal trials in that way, but we'd certainly, I'm sure that you can find a lot of judges on my court, and indeed, we will set up to do that. But unlike, I think it was Western District of Washington that did a seminar last Friday, a webinar on how to conduct Zoom jury trials, we are requiring the consent of both sides. It's such an unusual, I think a trial of any kind is so unusual to conduct on this kind of a platform, and everyone is taking certain risks, I think, by doing it over this platform. We are going to do those trials, but only if a party consents, if both parties consent to doing it.
Thank you. And I should mention now, we're a little more than halfway through the time we have. If you're on the phone and you need the MCLE code, it's 1985. Let me turn to Ms. Gray and ask some of the questions we've been getting about the changes that the court has made in terms of plexiglass or other physical things that are done to prepare us for when we're going back to trial, and what trials, if any, have taken place in the Central District.
Thank you. But currently, we haven't had any trials to take place in the Central District, meaning jury trials. But we're equipped, each courtroom is equipped with plexiglass, demarcation, and every courtroom, that's in all 3 of our divisions. One of the challenge when we first started trying to get plexiglass, we didn't know what we didn't know. We were listening to the experts, and some were saying, you know, the plexiglass is great, and some was saying it doesn't do anything. So what we did was I reached out to the judges, and for those judges who wanted plexiglass, we installed plexiglass. And for those who did not, we did not install plexiglass in their courtrooms. But, you know, we had to make sure that everybody was comfortable, that we were doing everything that we possibly could to keep everybody safe. Currently, we're still 80% teleworking. So when we do resume jury trials, I honestly believe we have all the PPE, plexiglass, and demarcation in place.
And haven't there been, I think there was at least one non-jury trial that took place by Zoom early on. Didn't Judge Anderson do one?
You know what? You're absolutely right. Judge Anderson did do one court trial remotely. And so, yeah, I did forget about that one. And as far as what I believe Judge Hamilton was talking, I think there was a question about, are we thinking about doing anything by way of Zoom, any type of court trial? I've just been in communication with the chief and as well as Judge Anderson. So, you know, we're talking about that. We're not there yet, but there's discussions underway.
Thank you. Susan, where do things stand currently at the Court of Appeal? Are all hearings done remotely?
All hearings are still remote. The court has basically been taking it a few months at a time when we have executive committee meetings quarterly. So the current decision was that through April, all of our hearings will be remote. We have another executive committee meeting next week, so they may extend that, or they may just say, you know, what really is the likely outcome, which is that we're going to keep doing them remotely until it appears safe to do otherwise. And we don't know yet when that will be. And that I think to the extent that anything opens up more loosely about that before it's an all clear, it might be that maybe some judges will want to go, because we sit in panels of 3, maybe some judges will want to go to the courthouse and sit together, but it seems very unlikely that we would want attorneys or staff in the courtrooms until it really is completely safe to do so. And there isn't any reason not to wait. We don't have the same issues that the district courts have in terms of not being able to go forward with trials. Our proceedings, it's very easy to do them completely over Zoom, and they are totally accessible to the public, even though our courthouses remain closed. The Ninth Circuit courthouses in Pasadena, San Francisco, Seattle, and Portland are all closed to the public since last March, and that has not changed, and I don't expect that to change really until it's totally safe to do that.
Judge Beckerman, what's going on in Oregon these days in terms of trials?
Oregon had a handful of trials in the fall, a couple civil, a couple criminal. We had one judge who did a bench Zoom trial. Unfortunately, we had a criminal trial in December that ended in a mistrial because somebody who had been in the courtroom reported exposure the next day. So we had to shut that trial down. We haven't had one since. We have some scheduled for this month, which I'm not sure if they'll go. But we've equipped 3 of our courtrooms to be COVID safe courtrooms with the plexiglass. We've tested the ventilation systems. There are really good, solid systems in place. So I'm hopeful that will go forward. We all attended the Western District of Washington training on the jury trials by Zoom and thought that was Very helpful. Again, we're all learning from each other, and there's people out ahead of us who we can learn from, so we don't have to recreate the wheel. I'm hopeful that we will get there. I had a jury trial set for March in a civil case. I offered the lawyers the Zoom option, and they had no interest in it. They'd much rather push it back until the fall. So I do think people have to be on board, but I do think, as with everything we've talked about today, the comfort level only continues to grow. So to the extent we need to explore civil jury trials by Zoom in the upcoming months, I do think the comfort level is going up as we see other districts doing it well.
Thank you. A couple of people have mentioned, in addition to trials, grand juries. And Mr. Alexander, you touched on that briefly on your earlier remarks. Where do things stand with grand juries now in your district?
Yeah, so the timeline in our district is we got an order sometime in mid-March, a general order from our district court shutting grand jury down. I think it was actually the day before grand jury was next scheduled to meet. And for a while, it was for a few weeks at a time or for a month at a time. Eventually, it became indefinite. Grand jury, and we typically have, in Phoenix, we typically have 4 grand juries going at any given time, and then also grand juries operating down in Tucson. We reopened grand jury the last week of September and had grand jury through the middle of November. I think it was 2 weeks before Thanksgiving was the last time they met. And it was then shut back down indefinitely. And that's still where we stand. We've started to hear from our court that we might expect to get jury back sometime this spring, although I certainly don't think it's going to be this month. And it's just been an ongoing difficulty, in that obviously without grand jury, it's very hard to move forward with a normal criminal docket.
Let's talk some more about the issues that are faced in the criminal practice. Mr. Hamoudi, can you maybe bring us up to date on the situation in your district and perhaps elsewhere in the circuit as to the risks that incarcerated defendants are facing with the pandemic levels in the jails?
Thank you, Judge Phillips. So the risk is that it's just impossible to socially distance in a jail. They're not designed for social distancing, and what is happening is that there are outbreaks, and the facilities are trying to contain the outbreaks, and some are successful, some are not. So what is happening is that a new practice developed for criminal defense lawyers ever since the pandemic started, which is through the First Step Act, is there's been a multitude of compassionate release petitions that are being filed with the courts. And these are very challenging, and they require certain criteria to be met. You have to demonstrate extraordinary and compelling circumstances. Now, the existence of the virus in a facility in and of itself is not sufficient. You have to have something more. And it's that the individual is particularly vulnerable to the virus. And you come to court and you're basically asking the court to release this individual from prison. And so early on, we were filing many of these and trying to make decisions about who to file and who not to file against. And the lawyers were under a lot of pressure because they were making decisions about something that they did not know. It was a disease that they did not understand, and prioritizing resources was particularly challenging. And our district has been granting a good portion of these, and then the reverse challenge is that when the probation office was on complete lockdown, and you're going to have to provide supervision for these individuals and manage them coming out. It is not the natural reintegration process that we expect from the prison systems into our communities. And all of this, by the way, we're doing from our homes. We're not working from the office. And what I started to understand was that the jail, the court, the office all existed in the home. And the kids weren't at home because schools were suspended. And so you're sort of transitioning from this one space to the next and trying to manage all of these things. It had a taxing effect. and I could see it in my colleagues. I could see it in the CJA panel. I could see it in, honestly, in the probation staff, in the prosecutors, in the courts. I could see the weight of this, and so whatever the weight was inside the prison was also being felt to a certain effect outside the prison by everybody involved.
And Mr. Samuels, maybe you could join in on that topic. And also, I don't know if you can speak, again, I know you're not speaking for your office, but about the effect the pandemic has had maybe in sentencing recommendations that your office is making, or pretrial release recommendations on newly arrested defendants.
Yeah, certainly. I think I just want to echo what Mo said. I feel like I've observed the same thing, and I think he put it in words really well. Just this sort of cloud that's been hanging over everybody involved in the criminal justice system, from prosecutors to defense attorneys to probation officers, folks at pretrial services. Everybody just seems to have really affected a way that I think is unique compared to practitioners in other areas. In terms of particular effects on how our office is operated, certainly one major effect is that the number of cases has gone down. In some sense, that is part due to the fact that we don't have grand jury, but we can still charge cases by complaint, and we're still doing that in cases, in certain types of cases. But certainly it's factoring into nearly all of the decisions that we're making, including those decisions, the fact that there's a pandemic going on. I think we've also seen from judges that it's affecting their decisions as well in terms of sentencing decisions. Detention hearings look a lot different these days, or I should just say sound a lot different these days, because this subject is present at every hearing, whether it's a detention hearing, sentencing hearing, or anything in between. And it's present in the arguments the defense counsel. I think it's present in many cases from the assistant U.S. attorneys, and it's certainly present in the judges' language that they're using and in the decisions that they're making. So I do think it's affecting things all around. Certainly we have made decisions not to seek detention in certain cases, or to be a little more open to alternative options. And I think as well, certainly as you alluded to, sentencing recommendations, you can imagine it certainly affects us. Imagine the type of case where someone is facing either a short amount of time in custody or time out in home confinement. Home confinement looks like a much different option than it did 2 years ago, perhaps, and is something becoming more readily used, not only at the sentencing stage, but also by BOP in terms of trying to get people who've been sentenced out of these and into environments where they can hopefully be.
Judge Dale, and then I'm going to ask Judge Beckerman the same question. Can you talk a little bit about what you've observed in terms of the effect of the pandemic and the conditions in the jail on decisions about pretrial detention?
Right. Well, under the Bail Reform Act, they didn't make a provision for how to take into account the pandemic, right? But the attorneys have done a very good job of raising the characteristics of the particular defendant and how the impact of being in jail or in a detention facility may put the individual at a greater risk. And I do think that the judges, we take that into account, just like we would some other underlying illness that the defendant has. But it is a topic, as Mo made reference to, that comes up almost, for a while there, it came up regularly. I can't even remember a case early on where the defense counsel, on behalf of his client, was asking that he be released on conditions because of the fear of being infected. And of course, that wasn't an unrealistic fear, because we all had it ourselves, right? But having to sort through that and analyze the true risk to that particular defendant based on his or her medical condition or other risk factors, and then weighing that against the potential harm to the community or against the safety of the community. But as Alexander mentioned as well, we have additional tools, and that the home confinement really means something more, at least during the initial stages of the pandemic, because the defendants, they couldn't leave their home to go to work, or they couldn't leave the country very easily. So the kind of the risk of flight was mitigated by the pandemic itself. But we also found ourselves adding as a condition of release that they needed to comply with all of the COVID rules and protocols within the state, as well as everything else.
Thank you. Judge Beckerman, can you speak to that as well?
Sure, and I'll be very honest. I found it very difficult to detain defendants, especially last March and April, when there was a lot of information we didn't know. And there was a deluge at the time of motions for detention review. So a magistrate judge had already detained a defendant as a risk of non-appearance or a risk of danger, and then I was to review it in light of COVID. And so the analysis of whether anything had changed because of the pandemic was a tricky one, and it was a balance, as Judge Dale has pointed out. But it was difficult, and we were already proceeding by video, and so the video screen is right in front of me. I could see the look in their eyes as I told them I was not going to release them, and it was, every single one of those decisions was a hard decision to make, and it continues to be to this day. Deb had mentioned the articles I wrote. The one I wrote last spring was part of just therapy to get it down on paper, because it was a tough time for a lot of us, to be sure. One interesting note, and in response to a question in the chat, starting last week and then ramping up this week, the individuals in custody in Oregon are being vaccinated. So last week it started to ramp up, and then this week there's thousands of inmates in our state prisons, our jails, and our federal detention center being vaccinated. So it's going to be interesting to see how that changes the calculus even more going forward.
Thank you. Judge Hamilton, how do you feel if you think it, I'm not sure if you feel this way or not, but do you think there's been sort of a tendency to give a sentencing discount because of the problems with the inmates and their risk of infection?
Yeah, I can't speak for my colleagues, but I certainly have been moved by that argument. It was an argument that the federal defender in my district raised fairly early on. And the argument is essentially that doing time in a facility during the pandemic is much harder than doing time when there's not a pandemic. And what they mean by that is that because of the potential quarantines and lockdowns that sometimes occur, the incarcerated at this point, particularly those who are in custody pre-trial, are not given access to any of the things that they would before, such as many of them are not getting contact visits with attorneys because there's no way to do that. They're not getting visits with their families. And if they don't have the money to make those expensive calls from the jail, they're going without any contact with their families. Many of the vocational and educational programs and spiritual programs that are offered for people who are in custody, and the GED programs, et cetera, are simply not offered anymore because the facility can't bring outsiders in. So when you think about that, I mean, doing time during COVID is really, really hard, and I can't help but take that into account. And yes, in my sentencing decisions, I find that ever since the beginning of the pandemic, I am taking that into account. And whether or not you want to call it a COVID discount or not, whatever you call it, I am definitely finding that I am moved by those arguments and have made different decisions that I would have made pre-pandemic. Similarly, with the compassionate release motions that we're we've been inundated with these motions. We all have tons of them. But those arguments have really educated us about a lot of different issues that, and I find that when I'm sentencing, I'm thinking about the compassionate release issues as well, because I know as soon as I sentence that person, I'm soon going to be signing an appointment of counsel to file a compassionate release motion. And I've had a couple of older defendants that I, on the record, said I'm taking into account the compassionate release and therefore am doing X. So yeah, the pandemic enters into every decision that I find myself making on my criminal cases.
Thank you. And as we wrap up, the last topic I wanted to get to is going forward, the future. And you mentioned earlier, I think that in thinking about this program, you came up with a list of the positives, what we've learned from it, and that you found on the whole that some of the positives were really important. I'm not going to say they outweigh the negatives in a situation where people have lost their lives, but maybe you could talk a little bit about your reflections on what we've learned and where we should go forward, where we should change the way we do business going forward.
Sure. You were addressing me because
yes.
I remember I said
Thank
that.
you, Phyllis.
Well, I think that because of the way COVID has changed our world, there are a couple of things that we have to do going forward. We have to adopt some flexible thinking. We have to embrace the change that has been wrought, and we have to learn from these experiences over the past year before we decide how to go forward. And I'd just like to name some of the positives, because some of the benefits of going to a remote environment for keeping the court operational. One of them is it's enabled us to drastically reduce the number of people who come into the courthouse. And that helps to mitigate the spread of the risk. It's helped us to manage our resources more effectively. We're able to utilize court reporters, probation officers, all over the district, as opposed to just the division to which they are attached, because probation officers, pretrial officers can appear in multiple different courtrooms on a given day and not have to deal with heavy traffic. We have been able, it's been more economical for participants and attorneys to appear. Think about all of the 30-minute hearings, 10-minute case management conferences. People don't have to get on an airplane and fly across state or across country to appear. They can do so remotely. It's cut down on the travel time for our CJA lawyers, whose time we're responsible for paying for to drive to the facilities where the defendants are housed, which in our district is sometimes a 2-hour ordeal each direction, in addition to the time. I've noticed the flexibility in that I'm able to get lawyers to appear on Zoom quickly. I just pick up something. Oh, I need to talk to the lawyers. Call my CRD. Can you get them on the phone? Can you get them on Zoom over the next couple of hours? I can do it. We can move cases, issues, motions along with less formality and do it far more quickly. Additionally, we've noticed that criminal defendants' families can appear remotely. And that's a tremendous benefit, particularly if they're in a different division. They would otherwise have to get on public transportation, on BART to go across the bridge. Instead, they can appear remotely. The media no longer has to also travel to participate, to hear and to hear our proceedings. They can attend. And one thing that was pointed out to me recently was that members of a class action objectors or putative or members who want to appear at a fairness hearing and be heard can do so remotely, even if they're across the country. So I think that the remote technology has very positive aspects. And believe me, my court will be working on determining which of those aspects we would like to retain going forward. But I will tell you that you could not wring the Zoom button out of the hands of the judges on my court. We have gotten so used to it. I only hope that going forward, the administrative office makes it possible for us to continue with remote proceedings. And lastly, so that you don't have to come back to me at all, in terms of the losses, the real negatives, the big ones that I see are the loss of opportunities for in-person collegiality among our colleagues. I haven't seen my colleagues, face to face in months, and I'd love to see that. And the loss of the same collegiality with our staffs, with the staff that works for the court and with our law clerks, those water cooler conversations, they're all taking place remotely, and I miss those. And there's been a loss of autonomy because all judges are used to, in the federal system, right? We're all used to doing things the way we want. We are now not able to do that. But the upside, that's a negative, but there's also an upside. And that is, at least on my court, we've learned to share. We've learned to share in a way that we were never forced to do, to share and to collaborate. And that's a wonderful thing.
Thank you. Ms. Gray, can you comment on that? What do you think we've learned and what we will continue to do differently going forward?
You know what, I think Judge Hamilton really drove it home. I think technology, of course, is just going to be at the forefront. We was a court who really kind of frowned a little bit on teleworking. Now we have departments will never come back into the courthouse. We have reduced our footprint and made them permanent teleworkers. We found out that they're doing more by being home and don't have the distractions. So, really, truly, I tell everybody that I strongly believe IT is the heartbeat of what we do. And without having IT at the forefront, we would have been totally lost. So again, teleworking, I think, is going to be at the forefront. The United States Marshal Service reached out to me as well and said, Kiry, I hope we don't go back to doing business like we were doing, especially as it relates to the BOP and doing Zoom. And it just makes things more efficient. And I keep saying, shame on us if we don't learn something from this pandemic.
Judge Beckerman, do you have anything to add on this? What we've learned, what we will keep doing differently?
Let me give you one practical and one more big picture. On the practical side, I may never conduct an in-person settlement conference again. I am very much enjoying doing those by Zoom. There are huge cost savings for the client, the lawyers who don't have to travel. And I think they're just as effective. I agree with Judge Dale. The win-loss record so far to date amongst our magistrate judges is about the same. They're just as successful. They're much less costly. But from the big picture standpoint, I think we've been able to conduct sort of what I see as an amazing experiment of meeting criminal defendants in their homes. And in terms of some people who are appearing out of custody or appearing from home, but even I see it more so in our court programs. We have in our reentry court, we are doing it by Zoom. I can see people in their home. I can meet their spouse and their kids and their pets, or I can see them in their workplace. And I'm saying this as a former AUSA, the more you get to know what somebody's all about, the better decision you're going to make with respect to sentencing or consequences. And I really think it's opened the door for us to look inside people's homes, get to know people better, more than just their worst decision. And that increase in the humanization of the people in our court, rather than just seeing them at counsel table, sitting with their lawyer, I think has really had an impact. I hope there's a way we can harness that impact in our criminal proceedings going forward.
Thank you. Mr. Hamoudi, what do you think we've learned and what have we lost?
I think what we've learned is our capacity to adapt, to be nimble. Our institutions were like tested to their core, and we showed up, we stepped up when we responded. And I got to say, I'm fairly proud of like being part of that system. I really want to echo what Judge Beckerman says, is that we've really started to think differently about the people we interact with. And I think that that's very important moving forward. I also think that one of the things is that I miss being in a courtroom. I miss seeing people and taking the lectern and just the day-to-day experiences. We're human beings. We're very social. We like to be around each other. I don't think we're designed to be in these virtual spaces. My sense is that at some point, we're going to be back, and we're going to look back and say, boy, we learned some really great lessons from there. I would love to see a couple of things come out of this. One of the things I'd love to see is a weekly virtual contact between judges and defendants, just to check in, to make sure they know that they're keeping in touch with them, and sort of especially those on supervision. I think that would be very helpful. Them feeling like they're being held accountable. It could occur virtually, and I think that would be a good help. The other thing I would love to see is settlement conferences in criminal cases, where I know Rule 11 prohibits them. But what we've learned is there's a huge backlog, and if we could get somewhere where we could involve a judge, or maybe a retired judge, or somebody to come in and start working on settlements, that's going to address some of the backlog that we're going to have to meet across the country. But I'm really proud of how everybody stepped up. That's my final thought.
Thank you. And last, but well, not quite last, but Alex, what would you add to that?
Yeah, I think largely I would echo that. I think, like Mo, I really miss being in a courtroom. I think, like others have said, I really miss the collegiality. And I think a lot of us will be very eager to get back to that. But I think Judge Beckerman's right that one of the biggest things that we've gotten from this is we were forced to look at things a little bit differently and get to know people in different ways. And my hope is, working for the government, I'm always a little worried that in a situation like this, for example, we might just fall back into our old ways because we're not great at change. I hope this will trigger a little bit of a mindset shift for a lot of us, where we'll look for ways to seek out some change rather than just changing when we're forced to by a global pandemic. And I can see in myself and my colleagues a little bit more of just that thought process, looking for ways to change things in small ways and large. And then a couple small things that I think may have been benefits that might stick around, at least in Arizona, and they're benefits to the community, not necessarily the attorneys. One is our district did not traditionally use very robust juror questionnaires. Typically, they were just about scheduling and hardship, and then everything else was in the courtroom. So a lot of people who were never going to be viable jurors were forced to come in. And in some cases, we have jurors coming in from Northern Arizona from 4 or 5 hours away for a couple of questions, and then it's clear they shouldn't be serving. I think those more robust juror questionnaires may help some of those jurors not have to make the trip. And similarly, this is sort of particular to my work, but I work cases primarily for Indigenous communities, and in particular from Northern Arizona, where a lot of our victims and our witnesses are 4 to 5 hours away with limited technology. They're in rural areas. They often have limited transportation options. Our victims in particular are often eager to come down to Phoenix to come to court, don't always have the ability to do it. Our court is now a little more accepting of victims appearing for hearings telephonically, and that has been a huge help to many of them to either feel heard, to literally be heard, or to just feel a part of the process. And I think that sticking around will be another thing that might help people in small ways.
Thank you. And we've got about 10 seconds left. So I don't want to forget you, Ms. Gilmes, as to, from the Court of Appeals perspective, what you think we've gained and what will change going forward.
I think that certainly there is a new understanding at the court about staff teleworking. Staff who traditionally didn't have that option will not only have that option, but will be encouraged not to do it full time, but to do it more. And I think that I can't speak for our judges, of course, and every panel will always have the discretion themselves to decide when and whether to allow attorneys to appear remotely. But I would be very surprised going forward if panels were not completely open to those requests for a variety of reasons. We've always allowed it with specific, hardships or whatever, but I just think we may end up with, a remote day of argument where all the people who want to appear remotely will appear remotely or something like that. I think that will be a much more of a viable, acceptable way to do it for those attorneys that want to do it.
Thank you. Thanks to everyone and for all of your insights. I hope they were helpful to all of those who participated. Now I'm going to turn it back over to Deb Gresham.
Great. Thank you, everyone. As you can tell, we could be talking about this for a long time. There was so much to cover and so much more to cover. And we have great questions. I'm sorry we ran out of time on those. Just shows you what interest there is and how much there is to cover. But thank you to all. First and foremost, our wonderful panel. Thank you all for taking the time today. We'd also like to thank our program partner, the Federal Bar Association of the Western District of Washington, and our program sponsor, the California Lawyers Association Business Law Section, who are dedicated to serving the legal profession through educational programs, networking opportunities, and advocacy efforts. For further information about the CLA, see their link in the chat box or contact Chair Soyen Choi or past Chair Corey Weber for further information. There's a bunch of folks who've helped us with the CLE credits in our various jurisdictions throughout the circuit. We'd like to thank Hughes Hubbards for sponsoring the California MCLE, the Federal Bar of Idaho, Federal Bar Association of Idaho for sponsoring the Idaho CLE, and the Federal Bar of the Western District of Washington for sponsoring the Washington CLE. We'd also like to thank all of our partner FBA chapters in Arizona, the Eastern District of California, the Northern District of California, Orange County, Idaho, and Oregon for helping us get the word out into all the law firms, including Perkins Coie, for so generously sponsoring spaces for law students and new lawyers to be able to join us and attend here tonight. Thank you all. We hope to see you in 2 weeks at the next program in our Courts During COVID series entitled Trials by Zoom on February 23rd, 2021. For more information about that, please go to the njchs.org website. And with that, good night, and thank you all. Stay safe and healthy.